Thank you so much to our panelists. We're really excited that we also get to, live with them, well, virtually right now, that they're here with so much expertise at Brooklyn. Oh, Danielle, do you have to do that? No, I'm just joking. It's fine. And also thanks so much to Celeste and Zoe for moderating. If people are interested, for Sparer Fellows who want to participate in the selection process, I know it's really time consuming, but it's so helpful to have fellows involved. Please email Debbie Bechtel. That'll be starting pretty soon. I think applications are due in early November. So, and then also our next lunch, which is on November 19th, I think. Anyway, if people are interested in talking about a topic and working on it, please let me know, and I'll be reaching out to people too to get started on that. Are there any other announcements? I know Stacy had an announcement, I think.
Got to have the 5-second unmute time. 2 announcements, really. First of all, I feel like I'm preaching to the choir a little bit here, but clinic applications are going to be rolling out starting next week. We'll have some information sessions, some small group information sessions, and then applications are due on November 13th. So even if you don't need to be informed, you could pass the word along to anybody else who might be asking that question. So this is for the spring. Also, some of you may have already noticed this, but the clinic faculty is offering a clinic speaker series all fall. There's a full program that I'm going to send around to everybody now that we've gotten ourselves more organized and have all of our Zoom links and everything. But the next speaker actually is Faiza Syed, who's speaking on Friday in the afternoon. And pretty much every clinical faculty member is doing one of these. 2 have already taken place. So I encourage everybody to come hear about, meet clinical faculty. Some of you know us already, but otherwise our topics are all interesting and timely. So please participate.
Thanks. Does anyone else have any announcements?
I'll just make a quick one. Hi, I'm Danielle. I'm the Executive Director of the Public Service Law Center. I just wanted to let everyone know that we've had a few questions of this. The PILC Fair is happening this year. It will be virtual. There will also be virtual table talk. So they're going to be a full PILC Fair this year. So, and 2Ls are eligible to apply for internships there as well. We'll be doing our big PILC program on November 16th. So stay tuned.
Thanks. Anyone else? Okay, great. So,
quick.
oh, sorry.
Yeah, no, very quickly. The Center for Criminal Justice is having an event next week, also on Wednesday night. The title, A Very Provoking, Is Criminal Justice Possible? We are seeking to explore sort of a lot of the threads in this current moment, questioning reform, abolition, anything else that can be entered into the fray. And so we have a great lineup of speakers Wednesday night.
Anyone else? Okay, great. So Zoe and Celeste, take it away.
Hi, everyone. Thanks so much for coming today or for opening your computers today. Our topic for this lunch is immigration, consumer protection, and election law in the pandemic. And we have 3 fantastic speakers. So I'm just going to introduce them, and then Celeste is going to kick off our discussion with some questions. So first we have Professor Codrington. Professor Codrington is a constitutional law scholar with a focus on constitutional reform, election law, and voting rights. He was previously the Bernard and Ann Spitzer Fellow and Counsel at the Brennan Center for Justice at NYU School of Law, where he focused on voting and election security, constitutional reform, and the rule of law. He also taught graduate and undergraduate courses at NYU Wagner School of Public Service on topics of law, public policy, and politics. Professor Codrington was also a fieldwork supervisor for the Brennan Center Advocacy Clinic and NYU Law School Clinic devoted to teaching public policy through real-world legal reforms campaigns that impact the laws of democracy and the regulation of election contests. He is a co-author of the forthcoming book, The People's Constitution, 200 Years, 27 Amendments, and the Promise of a More Perfect Union, which examines the history of constitutional amendments and the tension between the overall progressive arc of constitutional change and the conservative grip on the broader conversation about the Constitution. Previously, Professor Codrington was an associate at DLA Piper in the litigation, government investigations, and regulatory practices, where he participated in a variety of pro bono projects on behalf of individual clients, minority communities, and nonprofit organizations. He also clerked for the Honorable Deborah Ann Batts, U.S. District Judge for the Southern District of New York, and served as a staffer for U.S. Congresswoman Eleanor Holmes Norton. Next, we have Professor Raghavan. Professor Raghavan joined the law school after a decade in the public sector. His scholarship focuses on consumer finance. His current research interests include distributional equity in financial markets and the justifications for consumer financial regulation. Professor Raghavan previously served as Deputy Director of the Division of Financial Institutions with the Illinois Department of Financial and Professional Regulation and as Assistant Attorney General with the Consumer Fraud Bureau of the Illinois Attorney General's Office, where he investigated and litigated violations of state and federal consumer protection laws. Before that, he completed a 2-year public service fellowship with Prairie State Legal Services, where he created a clinic to provide legal assistance for low-income individuals with tax problems. He began his career as a tax associate at Skadden Arps, Slate, Meagher, and Flom. And then finally, we have Professor Syed. Professor Syed was previously a staff attorney with the Legal Health Unit of the New York Legal Assistance Group. Prior to her work at NILAG, she served as a refugee officer with the Refugee Affairs Division of the U.S. Citizenship and Immigration Service and an Immigrant Justice Corps Fellow at Sanctuary for Families, where she represented survivors of gender-based violence and trafficking in immigration matters. She also worked at Kirkland and Ellis New York City Public Service Fellow at Her Justice, where she represented South Asian survivors of domestic violence in immigration, family law, and matrimonial matters. And with those biographies, we're going to kick it off to Celeste, who's going to start our discussion with a few questions.
All right. Hello, everyone. And I would just like to say, again, thank you all so much for being here. And to the professors, thank you so much for agreeing to speak on these very important topics. So we just want to start off really by allowing each one of you to provide a 2 to 3 minute spiel about how the pandemic has impacted your practice areas. So Professor Codrington, if you would like to start, we will start with you and then we'll go down the line.
Sure. Thanks, everybody, and welcome. The pandemic and elections. Well, we are all sitting at home and we all need to vote. And the pandemic is creating its own obstacles towards our participation, not just in voting, but also in the other traditional political activities in the lead up to voting. So that includes going around to doors and canvassing and sort of supporting the party efforts. We've seen that this has been severely constricted because there are people are vulnerable for getting sick. And this has been particularly restrictive for communities of color, poor communities, because they have been disproportionately impacted by the pandemic and live and work and are with people who are more vulnerable to the pandemic. The way that we've seen this play out in terms of the courts and the legislators are, on the one hand, you've had some state legislators and other bodies that help administer and regulate elections try to do things to make voting more accessible and safe during the time of pandemic. So they would either pass laws or ignore laws officially to do things like requiring mail ballots to have notarization or witness signatures, because those would obviously undermine the idea of social distancing. They have tried to expand ballots. They've tried to place ballot drop boxes, things like that, all aimed at allowing people to vote in a way that is both socially distanced and therefore safe. On the other hand, you've had the court contending with this. And while in the beginning, there have been a number of wins on the side of voting rights and for expanding the access to the franchise during this time, recently, we've seen the courts, the federal courts, appeals courts, and the Supreme Court sort of invalidating these victories, and specifically in the name of the Purcell principle. That is a very murky, ill-defined principle, which I'm trying to grapple with in many regards. But in effect, the idea is that we should not be, or courts should not be intervening in elections as they near. So this has been applied by the appeals courts and the Supreme Court in a heavy-handed way to undermine findings from lower courts about whether these different ways of trying to make voting more accessible are permissible under law. So right now it's very active. There was the Fourth Circuit just decided a case 12-3 that says that North Carolina, for example, should be able to extend its ballot receipt deadline. Just recently, a case came down. The Supreme Court was divided 4-4 about a sort of similar discussion, but it kind of touches on other nuances decided by the the Pennsylvania Supreme Court, and on and on. So right now, again, very much the battle is over the ability to participate both in elections by voting, but other sort of activities in light of the pandemic.
Thank you, Professor. And Professor Raghavan?
Okay, great. Thanks for inviting me. So, I think a lot about consumer debt, and I'm not sure there's really a coherent story that we can tell about the relationship between consumer debt and the pandemic. I think that people like me anticipated that there would be a big crisis in consumer debt that would be triggered by the pandemic. And the reasons that we anticipated that happening, I think, are pretty transparent. So lots of people have lost their jobs, and with the loss of income, one would naturally assume that individuals and households may start to rely on fringe financial products to supplement their income, and then simultaneously have this old debt that predated the crisis that now they needed to service but don't have the income to service, and so you may see debt collection abuse. So these sort of like concerns that you would see arise in the supply of fringe financial products or predatory loans, and you'd see lots of debt collection abuse. And that hasn't quite materialized. And part of the reason that it may not have materialized is it actually has, and the data is unclear, and we don't really know. It's hard to sort of tell if people are taking on more debt. But I think the other reason is there's been these band-aids. So at the federal level, there was the CARES Act, which had these stimulus payments that phased in based on your income, had enhanced unemployment, which expired this summer, and there was forbearance of allowed for forbearance of student interest and mortgage payments. And then there was this patchwork of responses from states. So some states suspended debt collection proceedings. New York suspended the collection of certain kinds of debt. And I actually don't think that New York, and correct me if I'm wrong, I don't think New York has suspended debt collection proceedings or repossessions, but I think it's suspended the collection of certain kinds of state debt. So like these band-aids may have helped slow down this consumer debt crisis that I thought was going to take place. But I think there's real reasons for concern. One, the band-aids are expiring. States and localities keep extending forbearance on the collection of debt, whatever they had in place. But some of that's being challenged by lenders, and who knows if it'll stay in place. It's not clear we're going to get any kind of new sort of like CARES Act. There's this HEROES Act, and I mean, you all know just as well as I do whether anything's actually going to materialize, but it seems like we may not get anything before the election. And then I'm happy to discuss this in detail later, but there's been a bunch of deregulatory moves by the federal government to try to clear the runway for both potentially abusive debt collection practices, but also for lenders to expand the supply of these predatory products. And so, yeah, I think right now the way it's intersecting is not clear. I'm worried, but I do think there's reason for hope, and I'm happy to talk about that later. But so that's kind of the main takeaways.
Thank you, Professor. And now Professor Syed.
Thank you all for having me. So the pandemic and the resulting federal response has had an impact on pretty much every aspect of the immigration system. So for a while, the entire system was just at a complete standstill. So the Department of State halted processing visas abroad. They halted the resettlement of refugees. Within the country, the US Citizenship and Immigration Service stopped adjudicating most immigration benefits and stopped scheduling interviews. And, going back to what Professor Codrington was talking about, the election, this included the suspension of naturalization interviews and of oath ceremonies for people who had completed all other steps to become citizens. And this has had a huge impact. An NGO actually released a report really recently that stated, as a result of the suspension and the slower startup of processing these applications, 300,000 people will be prevented from completing their naturalization process in time to vote, which is, really sad to hear given how important this upcoming election is. Now, a lot of the immigration processing has started back up, but at a much, much smaller scale. So for example, I learned recently that one of the local asylum offices is conducting asylum interviews now, but at a rate of 3 interviews per day. So this is problematic because USCIS actually reported in April to Congress that they have a backlog of 2.5 million cases. And the largest backlog is in the asylum realm. So the shutdown and the slower interviewing rate now is just going to make this backlog balloon even further. Now, the pandemic, or rather the federal response to it, has also had a huge impact on the ability of people to travel to the United States. There are various travel bans currently in place that I can talk about in more detail if people are interested later. And COVID also has had a huge impact on individuals being held in ICE detention centers. The virus has spread through a lot of the detention centers, and ICE's response, they've been really reluctant to release people from detention. And, they haven't been testing that many people in detention centers. And there have been, there have been a number of deaths as a result of COVID spreading in detention centers. So it's had a pretty widespread impact on the immigration system as a whole.
I think Zoe had the next question for all of you.
Hello. The technical logistics of moderating remotely. So in light of the pandemic, a lot of states are changing the way in which they hold elections. So for example, some states are using mail-in voting in a much more widespread manner, or even for the first time. What are some of the new legal issues that are arising as a result of these changes, Professor Codrington?
Yeah, so there are a few that I guess I'll highlight. One is the fact that prior to this point, most places were not doing mail-in balloting or no excuse absentee balloting as widespreadly as we have. So there are about 5 or 6 states in the West that do conduct their elections mostly by mail, but the rest of the states did not. And as you might imagine, when you move from one system to another system, it causes all sorts of strains. And usually when you do that, you also have a great sort of education campaign as to how you conduct that. So what we're seeing is especially during the primaries when the pandemic sort of was at its outset, you had a lot of places say that will allow this widespread mail balloting, but then they were overwhelmed in the processing of those. So this has impacted them before when they were trying to send out ballots, and I think those who are in New York, I myself even got a ballot that was for somebody else. So there's all sorts of mistakes in that regard, but then also afterwards, and that's whether or not you will meet the state's deadline in having the ballots returned. There's a ballot receipt date, and that varies by states, but that's part of one of the battles that are going on. Another thing is the sort of overwhelming of the mail system in general, and there has been, to put it succinctly, a pretty all-out war on the post office, conservatives having, and they have their separate sort of policy issues for having this regarding like the funding of the system and sort of unfunded liabilities and pensions and the like. But then there's also the way that it sort of impacts with the election in light of the president's unfounded claims that there's going to be massive vote fraud because of this, like the massive vote fraud that somehow was not discovered relating to his election in 2016. So that kind of has coincided and created a problem. And then there's a problem, I think, about from the education campaign standpoint, which is that without sort of having done these big education campaigns about how you go about filling your ballots out, there are a number of ballots that we have seen that are being discarded or not counted because of technical non-compliance things, like so putting your signature on the wrong place or not. Pennsylvania, there's an issue about naked ballots. There's a funny campaign about it, actually, if you want to go see something kind of funny in light of all this. But like all sorts of things you need to do that really are harder to know when you just switch from one system to another. So that in addition to some of the things I described earlier in my opening.
Thank you so much, Professor Codrington. And one thing that I want to think about is thinking about how a lot of these things are intersecting. I want to bring a highlight to immigration and consumer protection and think about, so we know that this has had an impact on the average consumer, right? Professor Raghavan talked about how consumers are struggling with debt collection, or lenders are struggling with debt collections and consumers are struggling to pay their debts. How has this impacted immigrants, and in particular, a very vulnerable population of undocumented immigrants? How has the pandemic struggled or affected their ability to maybe be given rights that they should be given and aren't getting, or even rights that should just be given to anyone because of human rights, but they're not getting because we have a broken system?
Yeah, so I think for immigrants, the pandemic has had a really big impact. Thinking of undocumented immigrants in particular, they were actually excluded from the CARES Act, so they didn't get that $1,200 check that everyone else got. The original CARES Act also excluded people who may be citizens or green card holders and who are married to undocumented individuals from getting access to relief as well. I think that was later changed because there was a lot of pushback against it. The other impact, another population that it has a big impact on is asylum seekers. So I already hinted at it originally. Asylum seekers who are already here, they're seeing a huge slowdown in the processing of their cases. The immigration courts themselves totally shut down. So anyone who had, a very strong asylum claim and who wanted to have their case heard for a while, and to some extent continuing until now, immigration courts are shut down. So people can't get the relief that they need, such as asylum. Also, in terms of people being able to come here and seek asylum, that is basically just not happening. And it actually involves an intersection, interestingly, of the CDC and immigration. So the director of the CDC issued an order under this really sort of obscure US health law. It's at 42 section 265, which basically allows the director of the CDC to prohibit the introduction of individuals into the country who might introduce a communicable disease into the US. And using that law, they basically shut down the ability of people to come here and seek asylum. So someone who is now coming to the border and asking for asylum is just immediately being sent back to their country or being held for a short period of time and sent back to the country. And you may have seen some headlines recently detailing how the CDC didn't want to issue this order, but they were pressured to do so by the administration because the administration is so against asylum seekers, and their goal really has been for a very long time to just shut down the asylum system. And unfortunately, the pandemic gave them the perfect way to shut down people's ability to seek asylum.
Thank you, Professor Syed. Turning now again to consumer protection, I think one of the things that we've seen and we've heard about is this issue of liability, maybe for nursing homes, or now we're even seeing the airline industry put out their own studies about the safety of flying. So Professor Raghavan, can you talk a little bit about some of the liability issues that are arising out of the pandemic, and then maybe even give us a forecast of some claims that you think might be made once the pandemic, I don't want to say is over, but once the dust kind of settles with all of this in terms of consumer protection? Or do you think those types of claims are going to be possible to even be brought in the first place?
Sorry, I got some weird message. Yeah, that's a good question. I think that, well, I'll talk about lenders, which I know more about than I do nursing homes and airlines. And I think that the kind of claims that we can make and how successful they'll be will turn, unfortunately, on the election results. And so let's say the election goes south, which I don't know what that means for most of you, but I assume it means the same thing as it does for me. Then I think we'd look to states and we'd look to individuals to try to make claims against institutions that behave badly, or that private companies that behave badly. And I think that those claims, probably the main consumer protection claims would be state unfairness and state unconscionability claims. And there might be specific statutes that apply to these private entities, and you'd have to look. So maybe there's some nursing home statute and nursing homes violated it, and there could be some liability for that. But and maybe there's tort claims, but at least consumer protection, as I think of it, is as I traditionally understand it, it'd be a unfairness or an unconscionability claim. So, and if we have a Trump administration and states that are bringing those claims, I think you do have to worry about federal preemption, or some kind of preemption being asserted in some manner, or some new legislation being passed that would insulate these institutions from liability. If we have a Biden administration, then then potentially these claims might be more viable, and maybe there'll be like some federal entities that are willing to bring these claims. I think like how successful they'll be is sort of contingent on like whether you have like this intergovernmental opposition to these claims, and if you do have that, particularly if it's the federal government that's on the side of private enterprise, they may not be as successful. And then it just also depends on the composition of the Supreme Court.
Thank you, Professor Raghavan. And so this is a question that I would like to pose to all three of you. Something that I think we can all agree on is that the COVID really highlighted a lot of the holes in our system and has really encouraged a lot of the tough conversations in a lot of spaces that the conversations never would have happened. So something that I would like to think about are, a lot of the things that are currently happening are very kind of like Debbie Downer. Do you think in your field that there are any conversations that would have implications for positive change in the future and possibly like change the system of how your field works? So like in election law, do you think that allowing more people to vote remote through mail-in ballots would happen permanently? Professor Syed, do you think that immigration, that there'll be an easier process, in the I know a lot of this is like thinking to the future, and I can anticipate some of the answers, but I'm just really wondering, like, what do you think how do you think the COVID is going to, what conversations are being had, and what positive impacts is that going to have?
I'll start, and I actually like the sort of positive spin on this. I think there are discussions about making voting more widespread through the mail. I think another sort of positive externality of that is if more states move towards that, then they would also have an incentive to bolster the mail and the post office in general. So that could be great, and we know that the post office is one of the federal government's largest employers in the federal government, and they also employ a lot of Black and brown folks. So those are all good things in my mind, at least. And we've also seen that states like Oregon, states like Washington that resort to mostly mail, they actually have really, really high participation rates. So whether we have that, or whether we also point towards like some of these really indestructible ballot drop boxes that they're putting out there with cameras and security and all the stuff that they're saying that's necessary to prevent fraud, again, which doesn't really exist. All those things might become a permanent feature of our electoral structure. So that's a great thing. Professor Raghavan talked, he alluded to the differences between what the possible is depending on the outcome of the election. I think that's a very, very big factor in the mind of folks who are working in the election law space, particularly because the Democrats put forward H.R. 1, which is this omnibus election reform and anti-corruption reform bill that includes all sorts of things about independent redistricting commissions and automatic voting and sort of all sorts of things to make voting easier, and other things related to anti-corruption that's been so persistent in the last 4 years. So that's also going to, I think, dictate a lot what pieces of that omnibus bill might be able to be achievable. But I'll stop there because I'm interested in hearing the positive parts of these other depressing areas.
Professor Syed or Professor Raghavan? Syed, there we go.
Okay, I'll go. I'm going to say it is very hard to be positive about anything immigration related right now. I was like struggling to think of some positives as you were asking this question. So I'm going to focus on some things that might seem very, very small and mundane, but they've certainly helped immigration attorneys. So one actually big thing is, and this is just a general theme throughout the Trump administration, is that states are taking steps to try to protect immigrants. So we've seen, states, who previously had agreements with ICE to transfer people from state custody to ICE custody, cancel those agreements because the Trump administration was so aggressively going after immigrants. That's not necessarily a positive of the pandemic. One positive state action because of some bad effects of the pandemic is certain states have provided money to undocumented immigrants because they were left out of the CARES Act. And actually, I wanted to clarify something that I said earlier. I think I said earlier that eventually mixed status families, meaning like a US citizen married to an undocumented immigrant, did get relief through the CARES Act. There was a lot of pushback, but I actually think that it wasn't ultimately changed. So those people were still left out. And so states stepped up. So I think in California, for example, there was some money given to undocumented immigrants who, I'm sure most people here know, but a lot of people in the American public in general don't know that, undocumented immigrants file taxes and give us millions of dollars in taxes. So it seemed very unfair to exclude them, and certainly very unfair to exclude US citizens or green card holders married to those individuals from relief. So it was great that certain states at least, such as California, stepped up there. And then some really mundane, but things that have had, a positive for immigration practitioners is just the immigration, the USCIS has been a little bit more flexible with certain requirements. For example, they used to be super tough about wet signatures, and the immigration courts as well. Wet signatures, they need wet signatures for everything. And it was really difficult sometimes to get wet signatures. In immigration cases, they've allowed us to submit scans of wet signatures. Tiny, tiny victory there. The immigration courts have also, and this can be both seen as a good, but potentially also a bad, the immigration court system is just, they're very slow to adapt to any changes. So technology-wise, immigration courts are so behind other courts. I know other court systems immediately were able to move to remote hearings, and immigration courts and immigration offices were kind of slow. But recently the immigration courts have been doing some remote hearings. It was much later in the game. So in March, I went to immigration court several times while the pandemic was happening in person with no precautions being taken by the immigration courts. Now they were allowing remote hearings, so by telephone. This is a positive because most immigrants in immigration court are unrepresented. And most immigration attorneys are concentrated in major cities. And so if this flexibility extends after the pandemic, it may be easier for, hundreds and thousands of immigrants who live outside of big cities to get representation if the immigration courts continue to allow sort of remote hearings. Immigration attorneys may be, more willing to take cases of those individuals.
Thank you so much. And Professor Raghavan, you'll get the last one.
Okay, so I'll sound a positive note. So I think that the conversations around what consumer protection means are much richer today than they were 12 years ago. So, 12 years ago, we had the financial crisis, which, unlike COVID, was caused by businesses and wasn't this sort of like natural event. Or maybe COVID's unnatural. But, at the time, at least in the academy and from policymakers, there was a lot of discussion about how to prevent the financial crisis from happening again. And kind of the main prescription was that we should have better regulation. We needed real rules for the road to steer business towards good action. We needed a new regulator to kind of police financial marketplace from abuse. And I don't think that was exclusively a top-down endeavor. I think maybe there were community advocates also pushing for increased regulation, but it was primarily top-down. And but that wasn't the only prescription that emerged from that period. And so, if you think about Occupy Wall Street, or you also think about homeowners organizing, they were pushing for different kinds of relief. So some of them certainly thought that regulation was warranted, but a big concern was debt relief because a lot of people had a lot of debt at that time, mortgage debt. They couldn't repay, and so new rules would have been great, but getting relieved of that mortgage debt would have been even better. And then there were people who were agitating for restructuring the financial architecture of America in a way that would be more beneficial for everybody as opposed to the wealthy. And so if you zoom out today, what emerged from that period, we got the regulation. We got a lot of regulation. We even got a new regulator, the Consumer Financial Protection Bureau. We got very little debt relief, and there was very little change in our financial architecture. So, one concern that I had is with all sort of the deregulatory moves in the last 4 years, what we might see is this energy to return to the past, to sort of fix the problems, to make the CFPB, which is now kind of the toothless captured entity that was designed to replace, function better. And I believe in that stuff. I think that's important. But I didn't want that to sort of take priority over debt relief and changing the financial architecture of America. And so, thankfully, a lot of the discourse today is not about fixing regulation, in part because this crisis wasn't driven by necessarily bad acts. But a lot of the discussion is about debt relief and about changing the financial architecture. And so, there's legislation to wipe out lots of student loan debt. There's even theories that a new Secretary of Education could use existing authority under the Higher Education Act to wipe out federal student debt. And there's lots of really interesting proposals on how to make the Federal Reserve work differently and work in a way that's more equitable. So, whether any of that energy will be channeled into real change is not clear, but it's at least hopeful that people are talking about these issues in a different way than they did 12 years ago.
Fantastic. Well, thank you all so much for sharing your wisdom and for kind of giving us some insight into the areas in which you all practice. Now we wanted to open it up to everybody who's here to raise your hand and ask any questions. You can just use the raise hand function in the chat box, and then we can call on you as you raise your hand. Joe?
Hey, thanks. So this is a question mostly for Professor Raghavan. I don't know if you've spent a lot of time in the New York City consumer courts, but a way for debtors to get relief there is that when a third-party debt buyer tries to sue and obtain a judgment, they often have difficulty in providing a sufficient number of witnesses. They would have to fly out a witness from the original lender as well as from the debt buyer. So with Zoom hearings and remote trials going on, I think one of the worries is that they're going to be able to get witnesses much more easily, and that this kind of, way that debtors could get relief, or at least were able to defend themselves against having judgments placed against them, might go away. So I was wondering if you, have thought about this, whether you think that this will happen in the future, even after COVID, and whether there are other things that you would identify in which, because of Zoom and the, justice being kind of easier to access, we all think is a good thing, but sometimes, in these situations, it can be a bad thing for the types of clients that we represent. So I'm wondering what you think of this.
Yeah, that's great. And so are these witnesses averring to the validity of the debt?
Yeah.
Yeah, so I wonder, this happened in the foreclosure crisis, and we talked about it in class, and I think that in that case you had a lot of affidavits and they were just fake. So I really do wonder if any of these I would be curious if any of these Zoom witnesses had actual personal knowledge. Who are these Zoom witnesses? How do they know that debt is valid? I think contesting it, it can be hard in individual cases because it's really taxing. You have to figure out who these witnesses are. Do they really have personal knowledge? But yeah, initially I would want I'm whenever this debt gets transferred to multiple parties and you have somebody who's really removed from the original transaction trying to enforce the debt, there's real questions as to whether they can establish that they really have the authority to enforce that debt. And it's probably easy for the debt industry to find people who can testify to the fact that they have the authority to do it. Yeah, so initial thought is that really true? And maybe it's easier over Zoom and maybe courts might be more willing to do it, but I think all it takes is one or two litigants to find fraud for there to be a ton of pressure on the debt collection industry to change or to try to halt all these debt collection practices. So I don't know. I don't know if that's helpful, but that's where I might look.
Thank you, Joe, for that question. Next, we'll have Madeline.
Hi, Professor Codrington. So my question was on the Purcell principle. You touched on it a little bit, but I was just curious if you could elaborate a little bit more on what would happen, for example, if it's the state that's acting as a defendant and it's winding its way up. How does the Purcell principle operate there? And then the alternative when it's the state as the plaintiff.
Yeah, so this is another interesting question that the Purcell principle has yet to let us know how it would deal with. So just to be clear, the Purcell principle is this principle. I think it's kind of a pseudo-legal doctrine that's kind of creeping its way up into legitimacy because of the way that conservatives are employing it. It is, it comes from a case in 2006, which basically says that when an election nears, federal courts should be cautious in their intervention because the result would be voter confusion. That opinion itself was extremely short, so it provided no guidance for how lower courts would put this in place or affect this. And so what we're seeing is a lot of invocation of the Purcell principle now, and have very little understanding what that means. So we don't know what is, like, what's an election approaching, like what's a reasonable date, right, where you would cut off, and is Purcell a factor in the sort of equitable considerations, or does it trump everything because you don't want that to be the case? Another issue that kind of came up with the Pennsylvania case is, so in Pennsylvania, there was a concern about mail-in voting and whether the Pennsylvania's election code would guide. Pennsylvania's election code said that ballots had to be received on the day of election, but the way that the Supreme Court of Pennsylvania interpreted this in accordance with not only the statute, but also the state constitution, was that ballots could be received 3 days after. I think it's 3 days afterwards. I'm getting a lot of the differences confused at this point because it's happening all over the place. But 3 days afterwards, and it would have to count. That case was appealed, and then the recent decision that came out was from the Supreme Court yesterday. It was a 4-4 split, so there was no stay of that decision. So therefore, the Philadelphia and the Pennsylvania Supreme Court stay ruling is in effect, which is a good thing, because if, to kind of get closer to your question, if you had the federal court intervening to say that state Supreme Courts can't be the arbiter of their own law, then we'd have a real cascade of litigation in terms of what that means. So one of the points that the Republicans appealing this to the Supreme Court, the US Supreme Court, said was that, well, you know, if you look at the Constitution, it's the legislators, specifically the legislators and legislators alone, that have the power to regulate the times, place, and manners of elections. And that's in the Elections Clause. But this kind of raises a question. Even if you give the power, if our federal Constitution gives the power to legislators to regulate elections, and the state constitution binds state legislators in accordance with their own sort of principles, separation of powers, checks and balances, what have you, under the state regime. Now, are we going to then say that the state Supreme Court can't rule what legislators can or cannot do under state law? So it seems to me that the Supreme Court, John Roberts, actually probably didn't believe what he actually the way that he actually ruled, but he sided with the liberals. I think he was very, very concerned about this sort of cascade, and because a lot of these cases are being decided on the fly without full briefing, without the sort of benefit of amicus briefing, without arguments. They're just kind of being decided on the shadow docket. I think it would have just opened a lot more issues without sort of full fleshing of the arguments. Notably, I say John Roberts probably doesn't believe what he ended up supporting, is because in the Arizona independent redistricting case, I believe it was in 2013, I'm going to say, the issue of what constitutes a legislator came up, and the liberal, in a 5-4 decision, the liberals said that legislator means any sort of valid lawmaking function. So in this case, it was direct democracy, a ballot measure that said we're going to decide how we district our elections sort of by independent districting commissions. So this was a ballot measure, and John Roberts was on the side of the 4 dissenting justices, said no, legislator means legislator in the very strict traditional sense. So in a sense, he at least ignored that for the time being in the ruling that came out yesterday or 2 days ago, and to sort of have at least a sense of stability at this time. And I don't think it's the last of the issue. I think we're going to hear it again. I just don't think the court felt good about taking it on at this time.
Thank you so much, Professor Codrington. And we have Professor Gatto.
Well, thank you all. This has been so interesting and great, and also thanks for injecting like a small note of optimism into it. So I had a question for Professor Syed. I was wondering, when you talked about that CDC mandate that they're not going to basically let in anybody, is there any limitation on it, like meaning time-wise, or whatever country you're coming from that's probably doing a better job than we are at preventing COVID, or any kind of test, or it's just like they can just sort of make an assertion of communicable disease, and then it can just last for a while.
Yes. So I think I probably made it seem a little easier than it is. So basically what the rule says is it bans the introduction of people who may spread a communicable disease because they're going to be introduced into a congregate setting. So generally what that means, when an asylum seeker comes, they're put into a detention center, and that's a congregate setting. So that's why it applies to asylum seekers, and they can be banned. Now, there's been an interesting interaction between that CDC law and this settlement agreement, which come to my talk on Friday, I'm going to talk about more, but there's this settlement agreement called the Flora Settlement Agreement, which deals with the detention of children. And so what was happening was when unaccompanied children were coming to the border to seek asylum and the CDC rule was in place, they were being detained in hotels, which violates the Flora Settlement Agreement. And so there was, I want to say a couple of weeks ago, a magistrate judge recommended to a district court judge that they not apply the CDC rule to unaccompanied children. And I don't know if the district court judge actually ended up agreeing with the magistrate judge. I don't know if that decision has come out, but that was one positive court decision, maybe exempting unaccompanied children to that rule, from that rule.
Thank you. And there was a hand that went up, but it's down. Do you no longer wish to ask your question? Okay, I was like, I know who you are and I don't want to call you out. All right, Anjali.
Thanks, Celeste. My question is also for Professor Syed. So sort of along the lines of health policy, I've been thinking a lot about the public health implications for undocumented immigrants, which started with the administration's policies of family separation, then spiraled into COVID, and now we have the most recent news of forced hysterectomies. How and where do we start with protecting the public health of undocumented immigrants?
It's a great question, actually. So again, states can take action. So for example, a lot of undocumented immigrants don't have access to health insurance because they are undocumented. But states have stepped up in certain respects, for example, in making COVID-19 testing free to all. So I honestly, under the current administration, I don't see any hope for, better access to healthcare for undocumented immigrants. Under the Biden administration, honestly, I'm not sure as well. The Obama administration did not have very good policies for immigrants also. So I do think this is an area where, people can pressure states to step up, and certain states do have better health, availability of health insurance, or just, getting to see a doctor for undocumented immigrants. You can probably guess which states, California, for example, but that is an area where states could be doing more.
Perfect. So I think with timing, that'll be the last question. So I will, I'll give it up to people who are more able to end this, like Gato or Sorgan. As I awkwardly mutter.
Just say thank you. I just wanted to say thank you. This has been so great to all the panelists and to Celeste and Zoe. So, God.